Hi, I'm Michele Shuster, founding partner of McMurray & Shuster. Welcome to our webinar, Auto Renewal Laws and What You Need to Know. And before we get started, I just have a few housekeeping items here. First of all, this presentation is being recorded and it will be made available on our website later today. So if you want to share it or if colleagues couldn't make it, feel free to share that with them later today. Also, if you have any questions, there is a chat box and you can put that question in the chat box and we'll get to it likely at the end of the webinar. But if we get it quick enough, we'll try to incorporate it into the presentation. So as I said, I'm Michele Shuster. I have been in the consumer protection world for quite some time. I started out as a chief at the Ohio Attorney General's Consumer Protection Section. And shortly after leaving there, went into practice with big law on the other side, helping companies comply with those regulations we used to enforce in the consumer protection section. We founded McMurray & Shuster in 2007 with other former regulators and former Attorney General Betty Montgomery. And we spend a significant percentage of our time continuing in this consumer protection, compliance, and litigation realm. I have presenting with me also Erica Hollar and Chris Weger. And Erica, if you'd like to start by introducing yourself.
Yeah, thank you, Michele. My name is Erica Hollar. I am a senior attorney here at McMurray & Shuster. Coincidentally, I started my law career here and then went and worked for a large retailer in-house here in Columbus for 5 or 6 years, and then had the pleasure of coming back the day everything shut down last year, and I have been here since and don't ever see myself leaving. And you know, it's a great place and glad to be back. Chris?
You know, we try not to take it that it was a bad omen, Erica, that the pandemic pretty much started the next day. But,
yes.
Got back. Then Chris,
what is it? Good afternoon, everybody. I am Chris Weger. I am also a senior attorney. If we're starting or pegging our experience of the pandemic, I started McMurray & Shuster about 6 months before the pandemic began. Prior to that, I worked for about 8 years at another large firm here in Columbus. And throughout my entire career, my focus has straddled both compliance and litigation, but on the consumer defense side, which is largely covering the topics that we're going to be discussing today.
Great. And of course, we have to start with a disclaimer here. While we are attorneys, this presentation does not offer legal advice. We always recommend that if you have questions about specific application of the law, that you contact competent counsel to provide that advice. And we are always happy to assist in that regard. So with that, let's go ahead and get started. You know, this is an interesting area of the law. These auto renewal laws have been around in general form for quite some time. When I was in the AG's office, we had auto renewal laws that were specific to industries. Gym contracts with auto renewing provisions were something that were of concern when I was in the AG's office, and something that we took care of. Other states also have similar laws to that, and on the federal level, as we'll talk about, so there are auto renewal laws that apply to certain types of situations. A really important concept that you have to keep in mind with auto renewal laws, most consumer protection disclosures, is that laws that we talk about today require a clear and conspicuous disclosure of certain types of provisions, and generally those are provisions about how the agreement will be auto renewed, at what length of time, how you can cancel, providing easy cancellation steps. So those types of things. As I mentioned, there are state laws that have narrower application than the ones that we'll talk about on the federal level, and some states with broader laws. So generally what we're talking about is contracting terms that we have known by many different terms over the years. Frequently I heard the term negative option when talking about these, or continuity programs, or other such terms. But that's what we're talking about basically when we're talking about these auto renewing laws. The continuity plans generally come in the form of contracts that have payment for services on some type of renewing term. Typically, we'll see these on a monthly basis, example, like treatment, or fruit of the month, those types of wine clubs, I think, also are going to fall under that type of plan. So, and then the automatic renewal. So satellite radio would be a good example of that. If you have different type of electronic subscriptions online, and the NFL channel package that's coming out again that we're here shortly if you have that with your cable provider. And then there's the free to conversion, and those are the types of auto-renewal programs that start out as a free item that's offered, and then they convert from free to a charge either on a monthly or some other time period, continuing with our programs and things that you'd be receiving. So on the federal level, it's been interesting to see recently that the FTC has become interested again in their auto-renewing laws. I think part of that has to do with the fact that if you've watched some of our webinars recently, the FTC ran into some issues with their ability to assess certain penalties in the AMG versus FTC case. And that was upheld by the Supreme Court. So now the FTC is somewhat more restricted in the type of penalties that they can assess. But if you look at the laws like ROSCA or Restoring Online Shoppers Confidence Act, they have statutory penalties of $15,000 per violation. So if the FTC has issues with through their FTC Act, then looking to other laws like ROSCA is a good way to enforce certain types of laws that they are. So with ROSCA, we're really talking about the online negative option sales. And as I mentioned, you're required to make certain disclosures in ROSCA about how the item will be billed. You are also required to obtain express consent, and you also have to provide a mechanism that makes it easy for consumers to cancel should they no longer want to be involved with the product or service that's being offered. Also, the two other laws that fall into the category of auto-renewing laws, one of them for telemarketing, and then the other one for negative options. And so with negative option plans, they're the types of plans that if you don't cancel at the renewing period, then they're automatically going to renew. Typically, these are the month-to-month type of plans. I think we used to use the Book of the Month Club previously when talking about these negative option types of plans. They're also known as continuity plans. Again, you have to make the same types of disclosures as with ROSCA, and that is making sure that it's clearly and conspicuously disclosed that unless the consumer cancels the product or services that are being offered, that they will be charged for that. So again, that disclosure component is very important. And then lastly, on the telemarketing side, there is a free-to-pay requirement or a free-to-pay plan requirement for sales that are made during telemarketing calls. And specifically, if you are providing a service or a product for free initially, and then they're going to be charged on some reoccurring basis after that, you have to obtain the last 4 digits of the account number that will be charged. And the purpose behind that is that in the past, the regulators had seen significant issues with credit cards that had been pre-acquired for some other type of product or service sale, and that credit card being removed without the consumers realizing that free to pay conversion type of sale. Also, you have to get express agreement from the consumer that's consenting to the purchase. and then you have to maintain the audio recording. And you should keep that for a period of time that would be equal to the statute of limitations. So usually up to about 4 years. So some unusual types of requirements if you're making those types of pre-fake conversion sales over the telephone. All right, with that, let's talk a little bit about the state auto-renewing laws.
All right, thank you so much, Michelle. Again, this is Chris Wager, and aside from that recap of the federal law, there are a number of states, as you can see from this list here. Our current count is 32 states that have their own auto renewal laws. The state laws vary in the different jurisdictions, so it really has created a patchwork of different rules and regulations that businesses need to be concerned about. On the left side, what we categorize as the onerous auto renewal laws, and the shorthand up there, and so everybody knows when we refer to ARLs, that is an auto renewal law. And of course, first on that list is California with the more onerous law. And California's law was enacted, it was back early in the 2000s, and actually the other states with onerous laws have actually followed California's lead and largely have modeled their laws after California's with some modifications here or there. And the reason why we consider those onerous is because kind of from soup to nuts, all the activities related to these sellers are regulated by these laws. That includes the initial disclosure that needs to be provided at the time of purchase, along with written confirmation, terms about notices when renewal periods become due, and a number of other requirements that we are going to, in broad brushstrokes, be discussing today. On the right there, there's states with general, we're calling general ARLs, excuse me. Those states are generally more limited. The common unifying factor between all of them is the fact that they require an initial disclosure, a clear and conspicuous disclosure. That goes to Michelle's point earlier about the underlying principle really here as being these UDAP concerns to consumers, where we're being, where a seller's being upfront with the consumer and providing clear and conspicuous notice that of the nature of the recurring transaction. So all those states share that requirement of having a clear and conspicuous initial disclosure, as well as in some states on that list, that is the only requirement. Some other states have some more minor restrictions here or there, but they are not what I'm calling the soup to nuts regulations, as is the case with the states with the more onerous areas.
State fronts have been interesting lately, especially in California. They have California Auto Renewal Task Force, or they call it CART. And they have assessed close to 100 million penalties over the last years. So when we're talking about these types of laws, it's because it's a per violation penalty, they very quickly add up. And in California, you have the district attorneys in several of the large states that are enforcing their regulations. So the state laws have been regulators lately.
And I don't think it should surprise anyone that California led the way and is at the top of that list. It's, again, these common themes we see across all different industries and types of laws.
Exactly. And then also, as Michelle was mentioning earlier, in addition to the broad laws that we're going to discuss more in depth today, we just wanted to highlight really quickly that states do have industry specific laws. And that is, there are certain specific areas and then kind of gym memberships. I'm sure most people on this call have been in that situation where you signed up for the gym in early January, and then July you realize for the first time, oh my God, I've been paying for this membership the last 6 months. That's sadly happened to me multiple times. Hopefully never again, but who are we kidding here? In addition to that, surprisingly, that you'll learn that online dating actually is an area where a number of states, including California and New York, have enacted specific laws regarding online dating. There are also home security services, as well as kind of home repair, home warranty, those types of agreements also face industry-specific laws. What these laws can include include expanded cancellation rates. So, on a typical auto renewing, there will be an auto renewal period, whether it be a year or a month or some other period. And typically, once that period begins, if you cancel, you're locked in for that term. However, in some of these industry-specific areas, the seller is required to refund the consumer for the prorated amount of the unused portion. And just kind of as an interesting aside, just showing how unique this can be, as an example, Ohio has a law with respect to the gym memberships where if a consumer moves 25 miles away from their gym, then they have the right to cancel without penalty. So that's just kind of a illustration of an interesting twist and just a reminder that that you do need to think specifically about your industry, whether or not there are any of these kind of odd quirks that may specifically apply to you. And going back, and this is a theme we hit on earlier, but I kind of just want to call out again, because at the end of the day, looking at these auto renewals, while there are specific requirements, technicalities that need to be met in order to check these boxes to say that you're complying, when we're dealing with regulators here, and especially looking at CART, like Michele mentioned, the big picture is to think about this from a common sense standpoint and looking at it in the context of why these laws are present and what they are meant to protect. Clearly, auto-renewing situations make sense both for consumers and sellers. It's nice to be able to, have something like a Netflix subscription where you probably use a lot if you're anything like me, and it's nice not to have to every month worry about, oh my gosh, I have to get online and renew this. It's nice just to have that that ability there. But balanced against that, of course, are always the situations where people feel that they become trapped in these auto renewing situations, either by for example, not adequately being aware that what they're buying themselves into, and by buying one thing, all of a sudden you're subscribing for long term, or even a practice. I think it's less common now, but I remember from my younger years horror stories of having those instances where you sign up for a recurring membership and it's impossible to cancel it. You call them and you get put on hold for 3 hours. It just becomes impossible and you just give up. So clearly there's a balancing act here, and it's important to keep in mind as you're approaching this, how as a seller can we be upfront with our customers so that it's understandable to them what they're signing up for, and they have effective ways to cancel these subscriptions if that's what they wish to do eventually.
I always liked to advise clients, if you do the work on the front end where you are disclosing to consumers what it is they're agreeing to, how it will be charged, when it will be charged, you're less likely to get those consumers who are dissatisfied and then want to cancel. So, I always encourage, not only legally is it the right thing to do, but from a customer service standpoint, if you are upfront and, develop those relationships with the consumers, I think it can save you on the back end many times.
Excellent point. And then, and this is the litigator side of me. This is the fun part I have, is the why it's important, and that's to scare everybody with horror stories of what has happened. And I just pulled 2 quick examples of settlements that occurred within the past year addressing auto renewal laws. And we see here at the top there's an Apple settlement for $16.5 million. I believe that was from 2020. And Michele, correct me if I'm wrong, but I believe that was a CART, the California regulator. That was a specific issue that they recognized and brought on behalf of consumers. And what that, and just for context here, I kind of like to color this because I think most people have experience with Apple and the App Store. What that action entailed was, with so many of these subscriptions on the App Store, you'd have a free 7-day trial followed by a monthly subscription, or it'd be a free 30-day trial followed by a 1-year plan. And what caught them up, and again, this goes to the technicalities issue about, really having to follow the black letter of the law, is that California specifically requires that you have an initial disclosure. And I wrote this down because it's a little bit of it's a little confusing here, but the seller has to disclose that the consumer will not be refunded their subscription fee if they do not cancel. And while Apple did provide terms, they did not include that specific disclosure. In addition, Apple's initial disclosure did not provide the notice of an easy method to cancel the subscription. Of course, there is an easy method to do it that you can access through your Apple account, but the fact that was not technically in the disclosure was a violation that subjected Apple to this penalty. Additionally, I guess I did not know this, but Bumble apparently is a dating app, and they were subject to a $22.5 million fine as well, a settlement. So again, these are the kind of horror stories that that show how important, and these are small tweaks. It's about, putting a sentence in a disclosure can be the difference between complying with these laws and facing a $16.5 million settlement with the California Task Force on auto renewals. And again, in addition to civil law penalties, there are other day-to-day concerns that a business faces, and on a more individual consumer level, and that is that a contract could be considered void and unenforceable in the event that the laws are not complied with. The consumer can terminate the contract without penalty. And there are even provisions that state that any goods or services provided should be considered a gift in that context. So if we're dealing with items of significant value, then clearly that can become an issue for sellers.
All right, I'll take it from here. So again, we talked about what are these laws, but why do we have these laws? And a lot of the reason that regulators have created these laws are to address specific concerns that they had and or that consumers had. And this just goes back to that general premise of your disclosures have to be clear and conspicuous. You don't want any violations of UDAP laws, which can vary state by state. But big picture, we just want to ensure that the consumers are on notice. Again, what are they agreeing to? How often will they be charged? What are they buying? What's included in their subscription? So they're also, we'll want them to be aware of the renewal terms. Is it a yearly renewal or a monthly renewal? And we can talk about it a little further into the presentation, but those time periods, the term of the agreement, those are important when we're looking at different state laws. Some of the concerns were that consumers needed to have advance notice of a renewal. So we'll talk about, if the agreement is going to renew in 30 days, the retailer is required to provide a notice to the consumer that, in X amount of days, your agreement is going to renew. And then, as we talked about before, Chris's horror story being on hold, you need to have effective means to cancel the subscription. So I think either we've all been in a situation where we've been frustrated trying to cancel something or know someone who has. And a lot of these new state laws have really implemented requirements that address those specific concerns. So as we said, state laws vary. There's kind of two buckets of laws that we can look at when we are looking at these state auto renewal laws. And we have those states that extensively are regulating all industries that are using auto renewal agreements. And then also there are, like we talked about, certain states that only regulate narrow categories. So whether it be your the gyms, the health spas, the home alarm systems. There's a lot of states that have those more narrow requirements. But with all of that being said, you see here many laws are premised on the same requirements. And again, I know we sound like a broken record, but it just goes back to those very basic principles of the UDAP laws and making sure the consumer is aware of what the seller is requiring, how long, all of that stuff. So kind of. So now we're going to get into kind of the nitty-gritty of what all of these state disclosures, just very high level, what it is that they require. And as we were preparing for this, Chris and I had some discussions, and we made note of the fact that not only do you need to look at the industry as you are developing your business practices, but it's also important to look at the means in which you are selling and or communicating to the consumer. So, if you are doing door-to-door solicitations, that might look different than someone who is doing telemarketing or someone who is having consumers sign up online. So all of these can be accomplished in different ways, and you need to look at the big picture of what is your industry and how are you selling it. And I think Michelle touched on that earlier with the TSR and some of those specific telemarketing requirements. first started. So the first thing is, what do we have to provide the consumer? Obviously, we want to strike a balance of giving them enough information that they are, one, aware of what they are agreeing to. They have all of the material terms of the transaction, but we don't want to overwhelm the consumer with too much information so that they're just like, I do not want anything to do this. And also, I mean, we want to sell a product, so we don't want to, obviously we want to be truthful, but we don't want to do so much so that it impacts the ability to close the deal. So what some of the laws require, just very broad sense, is that you must present the terms in a clear and conspicuous manner with legible text and visual proximity. So, this, I think, if you are doing an online sale, you don't want to have your terms in a pop-up that's 3 links away, that is white text on gray background. All of those things factor into whether it's clear and conspicuous and in close visual proximity. And I think one of the things that is oftentimes frustrating for our clients when we're dealing with these sorts of issues is, a lot of times there's not like a dictate of it has to be white text on a black background or size 12 font. There are best practices, but you really just need to look at the facts of what your transaction looks like. So, what it looks like for seller A could be different than seller B, but these are the big guiding principles that we want to keep in mind as we're going through this. So more specifically, you want to disclose that the subscription is going to continue until you cancel it. What is the cancellation policy? What does that look like? The fact that the recurring charges will be charged to their credit card, and the amount of those charges, that's also important. Sometimes you'll see situations where it's $1 for the first month, but then months after it's $50. So you want to make sure that you are disclosing to the consumer the different amounts of those charges. The length of the auto renewal term or that the service is continuous. So again, we'll get into that time frame a little more, but that's important not only to know but to disclose, and if there's any sort of minimum obligation. So these are kind of just like baseline disclosures of what you would want to provide to a consumer as a seller. So, sometimes we'll have clients or, sellers that we're working with and saying, this is a lot of information. Can we just send it to them after they sign up? Unfortunately, no. These are all material terms of the transaction that have to be disclosed to the consumer prior to them engaging in the sale. So not only do these auto renewal laws have these specific requirements, but just the general UDAP statutes would require the same. So you always want to make those at the outset. Okay, so number 3 here, we talk about obtaining consent. Some states require that sellers obtain their consumers' affirmative consent to automatically renew the agreement. So those of you who are familiar with telemarketing laws and the consent that's required with those, it's something a little similar, but it's got to be informed consent and it has to be expressed. You can't just, again, bury it in page 5 of, a 6-page agreement and expect that the consumer is going to be informed about those obligations and their ongoing obligations. So again, I think all of these and the ones that we'll just continue to talk about really just what can you expect that the consumer would want to know. It's just going to be good for everyone if we are upfront with these from the get-go. So Chris.
Okay. Now we are moving on to number 4, which is the area where it's congratulations, you completed your sale. They signed up for the renewal. Now what? First step is going to be after the sale is completed. In addition to the original initial disclosure, the consumer needs to be provided with an acknowledgement in writing that contains certain terms. Those terms include the initial disclosures. Again, the initial disclosures are the material terms related to the the auto-renewing program. In addition, there needs to be clearly and conspicuously disclosed what the cancellation policy is. And that can be, if, for example, if it's a month-to-month policy, when does the cancellation need to be received? A lot of our clients would require for kind of processing and other requirements, 3 or 4 business days, for example, prior to the term renewing in order for it to apply at that time. So you're going to want to have those types of written terms, as well as the information about how to cancel. And again, the last bullet point here, if the transaction involves a free gift, this is the comment that we made before about the Apple example, is this acknowledgement has to specifically state that the consumer has to cancel prior to the end of the trial period in order to not be charged. So you want to specify in that instance. And again, best practices here, again, as Erica mentioned, this is all going to depend on the channel through which you sold it. But to, so given that it will depend in that manner, some of the ways that you can effectuate this written acknowledgement is you can send this via email to the consumer so they can maintain this. If you're actually selling a good, you can have the written paper that has that acknowledgement included, along with the sales receipt, for instance, in that packaging as well. And of course, the best practice here would be to maintain this written acknowledgement as its own standalone document, as opposed to terms that would be buried in kind of the other terms or other contractual documents that are shared with the consumer. Oh, okay. Cancellation method. The common theme on all these is that the auto renewal laws require a cost-effective, timely, and easy way to cancel it. Again, that goes to you can't sign up online and then be forced to be on hold for 3 hours and get hung up on 3 times before you actually get a hold of someone who wants to cancel. Or conversely, having a sales practice where when you try to cancel, they harass you for an hour and try to upsell you as opposed to accept your cancellation, which within reason still happens to a degree. And, I mean, that is a fine line that the businesses need to follow. However, looking at each specific laws, they do vary. Some examples can be a toll-free telephone number, email, via US mail. Again, states' laws vary as to which, if not all of those, you need to provide. The newer development that we have seen is that newer state laws are uniformly requiring that if you sign up for a service online, there needs to be an effective method to cancel online as well. Now that can be done either 2 ways. You can that can be effectuated through an email process where you have a specified email address, you provide direction, unsubscribe@xyz.com with subject line unsubscribe me. You can provide that direction as one way. Also, if consumers have online accounts, there could be an option for them to unsubscribe via their online account. Again, that needs to be a process that will be easy for the consumer and kind of not buried and hard to find, and that's really the underlying principle there. And again, the one point that I also want to notice, and that we see a lot of our clients getting trapped by is that we need to ensure that the cancellation methods, if those change over time, that they still need to remain consistent with the notice that was originally given. So if someone signed up for service 4 years ago and you had a toll-free number and you've now discontinued that toll-free number, that can be an issue because your current practice is no longer consistent with your acknowledgement that you provided 4 years prior. So you really need to be cognizant to the extent that you're changing those methods. That you're not invalidating a previously a communicated cancellation method, or if you are, to consider altering those agreements and how you can put consumers on notice if necessary as to the new cancellation methods.
I would just add, in addition to providing the cancellation methods, I think this is kind of a no-brainer, but you also need to honor those cancellation requests as they come in. We see this a lot, or at least I've experienced it personally a lot with can spam, email opt-out requests. You send the request and they don't get honored. So same thing here. If someone is emailing you and if you have stated that email is a proper way to cancel, you need to make sure someone is monitoring that email address, make sure that they are timely honoring those requests and that the consumer does not continue to be charged for those services.
Definitely. The next point, so renewal reminders. Now this comes into play a lot of times, not necessarily dealing with a month-to-month renewal, but when you have a longer initial term, let's say that there's an initial 1-year period, and then let's say there's 1-year renewals, or there's month-to-month renewals after that. Again, this is going to vary by state. Some states have as short of a 6-month period at the front end. Some states it's a year. It's going to vary, but if you're doing anything longer than a month-to-month term, then this is something to consider. And all the states where you do business, whether or not a renewal reminder is going to be necessary before that next term kicks in. And clearly, the rationale behind this, right, is the concern that, you know, month to month it's easier. If you have your Netflix every month, you remember that. However, if it's a, you know, a 1-year subscription and you get hit with a $200 bill for an entire year, that's a lot different. And over the span of that year, you're a lot less likely to remember that renewal is coming up, and it's likely going to be a larger ticket number there. In addition to the longer periods, if you do have an initial free period, there can also be renewal. So you could have a free period for as little as 7 days, and if you have a pay period beginning after that, a number of states will require you to actually provide the notice prior to the pay period kicking in, so the consumer can have one last opportunity to cancel before having to pay. And as an aside, just kind of as a word to the wise, or a cautionary tale here, and kind of how every state law differ, I just want to highlight, for instance, the District of Columbia, their auto renewal law actually has a provision where if you have a initial free term, that you are not permitted to convert that consumer to a paid conversion, a paid month-to-month term, for instance, unless they affirmatively opt in. So advance of the pay period coming in, you have to provide them a notice, and they have to affirmatively respond that they wish to enroll in the pay period. So just like that, kind of landmine is there. That's the case for a number of states, and I just highlight that as kind of one issue where we really have to have our kind of ear to the ground here and be aware of all the different specific requirements that may be in each jurisdiction. As I mentioned, I already mentioned this, the next bullet point about how the timing varies, and we just have to consider both the initial term and the renewal terms and whether or not the renewal reminders are kicked in. Oh, looks like I just skipped one there. And then the content of the reminders will vary by state, as well as the method. Some states require that it be sent via US mail. In some states, email is sufficient. So again, we have to be cognizant of each jurisdiction and what they require in terms of what form that renewal reminder will take and what the timing is in advance of the renewal term and when you have to provide that.
Great. So I just want to add to that. We haven't really touched on this in much depth, but in terms of when the laws apply. So Chris talked a little bit about looking at the length of the initial term and then any renewal term. When you're looking at state laws to determine whether they apply to your transaction or not, a lot of the laws are premised on how long that initial period is. So some states, their auto renewal law will only apply if your initial period is 1 year, and then the subsequent periods, the renewal periods, are a month or longer. So that's how sometimes sellers get around some of these things, is if you structure it as a month to month versus year to year. And for the reasons that Chris talked about, states are more likely to protect consumers in those instances where the the terms are, they're committing to a longer period of time. It likely costs more money. There's more protections for the consumers in those sorts of transactions. So not only would we encourage you to look at these 6 things that we've talked about in terms of your agreement, but also the initial question is, do these laws even apply to my transaction? And because those vary so much by state law, we haven't gone into deep dive of it, but I wanted to just address it and make sure everyone aware. So as Chris mentioned, there are a lot of states that have these laws. They're continually changing. New states are making the requirements more onerous. More states that had nothing before are, adding to their list. So we're going to look at 2 states, just very high level, that most recently had laws that were signed into law by the governor. So the first one is Delaware. This one was signed into law just earlier this month. And, there's nothing too weird about Delaware or too out of the ordinary, but it applies to both products and services. So that's another thing as you're looking at state laws. Some laws only apply to goods, whereas others only apply to digital services. So, you have to look and see, first of all, what's the term, but also what is the service and what do the laws require. Again, here we'll see that they require a cost-effective way to cancel, and they state that it should be at least as easy to cancel as it was to sign up. So Chris hit on this before. You cannot sign up online and then require them to travel 60 miles to the in-person office to hand them your paper cancellation notice. Again, we look here, there's a private right of action, but there is almost what is, I don't want to call it a safe harbor, but there is a barrier for the consumer. They need to put the seller on notice before any action is initiated that there was a violation. And that can be done of the contract by email, mail, or any other method offered by the seller. And this will go into effect January of 2022, so right around the corner. And then Colorado, very similar. This one was signed into law on July 2nd, just of this year, and it broadly applies to auto-renewing consumer contracts. And there are certain provisions. Not only do we see the broad requirements that we've gone through, there are specific requirements in this law that only apply to online dating apps. So I think whereas I think when people think of these horror stories of these auto renewal agreements, a lot of us think of the gym memberships. I'm kind of out of touch with what the cool kids are doing now, but it seems like these online dating apps are the new problem industry, or what are giving consumers challenges on how to cancel. So what's next? There are currently 17 auto renewal bills that are in state legislation. So this just shows that they're changing, they're coming abroad, and we've got to be on top of it. So there you'll see Illinois, North Carolina, and California. They have bills that are pretty well in the process. Businesses are increasing the use of automatic renewals, and because of that, we're seeing increased civil and enforcement actions. And I think, I just think about my personal life and kind of how I've been living this past year. I know for one, grocery delivery services, with COVID and stuff, that's something that we have gotten on board with, and it's a subscription. I sign up for a year, and then a year later I'm going to be renewed. Or everyone's shopping through Amazon now, Amazon Prime. That's another example. So these things, they're just becoming more and more commonplace in our life, and I think regulators are aware of that, and consumers are getting savvy about those as well. And so then also the FTC announced in July that it's looking for a way to handle the complaints that it's getting in regards to these. So that's just, the fact that they have made a formal statement that they know that these things are happening, they're looking, it's on their radar. That just means that it needs to be on all of our radars, and we need to just make sure that we are one step ahead of it. And, we always say the complaints are what get you a regulator looking at you. So if you can keep your consumers happy, that's going to be leaps and bounds for you. Even if it's not from a legal standpoint, but like I talked about before, that customer service, if a customer contacts you with a complaint, like do everything reasonably to make that consumer happy, because if possible, we want to try to keep those complaints at bay, because that really is what puts a company in a regulator's eye. So we talked about some of the state and federal laws. I just wanted to mention quickly that there are recently, within the last couple years, Visa and MasterCard have both published their own versions of these auto renewal laws. Now, when we're looking at these, it's important to note that these rules do not have the force of law, so you're not going to, break a law per se, but sometimes I think it's almost more impactful. It could put your ability to process credit cards at risk. I think for a business, that sometimes is more detrimental than any sort of lawsuit or investigation by a regulator. Obviously, they're both not good, but if you can't process payments, a Visa or a MasterCard, how are you going to sell your business? So the Visa, that applies again to physical or digital products anytime that there is a free trial or an introductory offer that will then roll into an ongoing subscription. Their rules include enhanced notification procedures, a lot of which are similar to what we discussed with the state laws. You need to send notification of payment changes with a link for the cancellation. There's receipt disclosures. Again, a lot of the same things that we have already been discussed. MasterCard is a little different. Their rules only apply to physical goods. So if you, your Dollar Shave Clubs or your Wine of the Month, those sort of things where you are getting physical goods, these rules would not apply to your Amazon Prime subscription, your Netflix, anything that's purely digital would not be included in these rules. Now, that's not to say that it takes it out of those state and federal laws, but MasterCard specifically. And again, it's all about those enhanced disclosure requirements and that the ability for the consumer to cancel and to even know what, who the retailer, who the seller is. So they require that the statements, their credit card statement, have either the retailer URL or a phone number, because I know I've gotten credit card statements before where I'm like, XYZ retailer, I don't recall, I don't know what that is. So, and it's hard sometimes to know, remember what you signed up for, but by golly, they're charging me $40 every month and I have no idea how to get a hold of it. So having that website and phone number is helpful for consumers.
Okay, and to wrap this up, we just kind of wanted to leave some high-level takeaways that everybody can see on the list here. To me, I feel I can even further sum this list up by just saying that, this is a hot area. It's getting more and more attention, both legislatively and through regulators. We expect a lot more FTC action in this area. And the most important thing for sellers is, first is to know the products you're selling, know the characteristics so you have that understanding, so you can make that educated decision as to whether or not, you are selling something that has auto-renewing provisions and and whether those laws apply, and and therefore I think it's important then to consult counsel, or whether that be your in-house counsel or outside counsel, to understand some of the specific requirements that these laws enact, so that you're checking all those boxes to ensure that there's not a technical violation that can subject you to significant liability. And bigger picture than that too is the principle. We may have lost our video, but
you did, but we fine. So you keep talking, Chris, and I'll move my lips, okay?
Okay, perfect. I love it.
Go ahead.
And I noticed the thing changed there. Right. So the point that I was making is really just to take a common sense approach in addition to checking the boxes, just to make sure that that you're doing right for your customers by adequately disclosing what it is you're doing, and everything is clear. And the one last point there actually is another aside that we really wanted to mention in terms of a liability reducing step, and that is through an arbitration provision that can also include a class waiver. That can also be an effective means that, God forbid that there is a violation of an auto renewal law. That can be an effective way to effectively manage any consumer complaints or actions that arise from that. Last point there, and I won't rehash, this is the UDAP concerns. Again, that's the point of just taking a common sense approach in addition to the technical requirements, and also to be aware of the high risk areas. So if you are providing a free or promotional trial, if there's going to be a pricing change on your auto renewals, make sure that your terms contemplate that and you're adequately communicating those pricing changes to your consumers pursuant to the written disclosure that you provided. And to the extent that your terms are changing, if you have a 1-year initial term followed by monthly terms, make sure that that's adequately disclosed. And again, just so that consumers have a fair notice of what it is that they're signing up for.
It's probably even worth noticing. It's probably also worth discussing that Facebook. A lot of folks are selling on Facebook, and Facebook has its own subscription services requirements. This goes a little bit further than of the state requirements, and that it requires a privacy policy that's on your land. That if you're selling subscription services, also they require an empty checkbox, so there has to be an affirmative action by the consumer. So good to the federal and the state laws, the platforms that you're selling have their own restrictions as well. Make sure that you're taking notice of those and complying with them. But we've left some time at the end for questions. Questions submitted in advance. We also had one that came in during the webinar, so I'll give this to you guys. Can the terms, the auto renewal sent after the sale, acknowledgement required by some law? So can you email acknowledgement that are required in the auto renewal provisions?
Sure, I'd be happy to answer that. And that is, that goes to the distinction where there are two separate requirements in many of these laws, where there is the initial disclosure and then there is a written acknowledgement. So a written acknowledgement can be part of a communication that occurs after the sale, but that cannot take the place of the initial disclosure that has to occur at or before the time of the sale. So yes, there is a written acknowledgement afterwards, but it is important to remember that that is not a substitute for the initial disclosures that is required in many of these states' laws.
Yep. And then we had one other that came in just to touch briefly on the difference and the distinction between auto pay and an auto renewal contract. And Chris and I had some conversation about this. If you think about your Netflix subscription and how that transaction looks in contrast to your Verizon bill, and where we landed was with your Netflix, it is a true auto renewal. You are renewing that contract each month, and it is a month-to-month or whatever the term is. You are paying upfront for that monthly or yearly service. So if I cancel on the 15th of the Netflix, I'm not going to likely get my other half of the month back, pending any state laws that may require refunds for that. Versus with your, your Verizon bill that you may put on auto pay, those are different. They are, you are paying after the fact. So, I use my cell phone from January to February. I incur, my daughter texts way outside of our plan. We travel to Mexico. We've got international charges. Those are after the fact. And you would be paying for that for services that have already been provided. So that's the distinction. And, the other difference is if you cancel your phone service halfway through the month, you're only going to be required to pay for that half of the month, for the services that were actually provided. So that's kind of what we talked through as far as practical distinctions, how to help, because it can get a little confusing, just to help people understand the distinction between the two. Chris, I don't know if you have anything you want to add.
No, I agree wholeheartedly, Erica. And to me, the key distinction really is this prepay versus post-pay, and whether someone is being locked in for a term. We have had clients who have been concerned with auto renewal provisions, and if it's appropriate for your particular transactions, you can actually post bill for services so that people really aren't being locked into a term. They can cancel any time. It is the pre-billing where someone is then paying for a month in advance where that becomes the issue. that is when you go from simply just a continual service with recurring billing from a situation where you're having actual recurring terms of service. And short of that too, we've had clients that have tried to get creative as well. Even if you are pre-billing, you can work your situation, or you can work the provision out in a way where, there is cancellation abilities to cancel on the spot and get a refund, as efforts to argue that your situation is not a traditional, recurring subscription. But those situations are various areas on the risk continuum, and that's a difficult area, but there are definitely distinctions between the two. It is a gray area that the businesses definitely have straddled.
Well, and I would say too that I think this discussion just further shows that these state laws are all, while they have the same overarching theme and the same spirit behind them, they are all very nuanced. How do they define an auto renewal law or an auto renewal contract? Are there any requirements that they may have to issue refunds, whereas another state doesn't have that? So, again, we would just encourage you to get with your counsel, whether it be in-house or, outside counsel, to just kind of make sure that you are, you even know the realm of what is applicable to your business. So.
Fantastic. Well, we have no additional questions that came in. Do you have any other closing remarks, guys?
I don't think so.
Thank you, everybody, for your time. Get you off 4 minutes early. Lucky you.
Well, that's a gift back to everybody. If you'd like to contact us, our contact information is on the screen. Always happy to talk to you about auto renewal laws or other laws in the consumer protection realm. And have a wonderful rest of your week. We look forward to seeing you on the next webinar.